Hello, everyone. This is Eddie, and welcome to this debrief of question number one of the California Bar Exam from February 2019. Now, this particular question here was very unusual. Yes, it was difficult, and why is that? It's because it had many of the nuances found within the law of community property and wills and trust. So, with that said, let's jump right into it. And I do want to say that I am going to present some law here. And if you answer differently, do not worry. That can still be good. Why? Because the instructions specifically state that you should discuss the facts. You should analyze the facts. Now, it can be that you did discuss all of the proper elements and you still did not receive a passing score. And vice versa, if you did not capture all the correct elements, but you did a great analysis, you may have received a passing score. This happens all the time. Again, the instructions say discuss the facts. So let's go to question number one. It says, what rights, if any, do Wendy and Sid have in the California condominium? Discuss, answer according to California law. So let's go to that. And of course, we're talking about community property. I do have two questions. Number one, do we have quasi-community property here? And number two, if we have quasi-community property, when does it take effect? Now, let's talk about quasi-community property and why this particular question was a bit more complicated than usual. The answer is because many times when quasi-community property is tested, it's when the couple gets divorced. Well, here you do not have a divorce, you have a death. Quasi-community property can be discussed and is going to be treated differently when it involves the family code and when it involves the probate code. Now, when the real property is situated within California, it will be treated as quasi-community property. So with that said, let's continue. By the way, we are going to have quasi-community property here. I'll just do the spoiler here. Now, if we have quasi-community property, when does it take effect? And of course, we are dealing with a death here, and it's going to take place at the time of death. Now, I have another question. What happens if the decedent conveys the real property before he dies? Let's make this simple. Let's put this into context. Let's say hubby Hank. He does not like his wife. We're just assuming this. So he's going to give away his real property to himself and to his son. So he gets a good idea. Hubby says, I'm going to go on to Amazon. I'm going to order an ebook on how to convey real property. And that's what he does. He does a grant deed. And it's a joint tenancy with right of survivorship grant. Is that legal? Can he do that? Well, let's find out. Let's look at the probate code. Now, the particular language of this code deals with quasi-community property. The decedent's surviving spouse, she may have the ability to restore the one half that was given by the decedent. What are the elements that must be in place? So, the decedent died domiciled in California. That happened here. And there must be a transfer. What type of transfer? And also, it must be done without receiving consideration. So let's look further here. And let's see what kind of transfer the code states. A transfer whereby property is held at the time of the death by the decedent and another with right of survivorship. So that's what we had here. Now, the facts do state that Hank made the transfer and it was a gift to his son. So what are they doing here? They're saying discuss the facts. So even if you said, I'm going to argue that the wife should take everything, use those facts, great, or you can argue otherwise. So the conclusion that I have here may be different than what you have, and that is fine. So hubby keeps 50% of the condo, which will probably pass to wifey anyway under the quasi-community property laws. And son will have to restore 50% of the interest to Wendy. So Wendy will have restored to her 50% interest in the condo. And I wrote subject to the following conditions. I love to write that because it keeps me organized and also I want to get more points. And of course, you talk about that will. When was that will? What was the year of that? It was in 2008. And what does hubby say? It says that his property will go to wifey. Disposition, she will get 100% of the condo. Let's go on to question number 2. And that says, what rights, if any, do Wendy and Bill have in the State X house? Discuss, answer according to California law. And again, we might have here quasi-community property, but this time the house is outside of California. And here, Wendy may have a difficult time getting any interest in that real property. And of course, the probate code, again, it says all real property situated in the state X house outside of California, so it will not be quasi-community property. And of course, I'm going to write subject to the discussion below because I want to get more points. I want to stay organized. And what am I going to talk about next? I'm going to talk about the action by party to change the character of the property. And we have a conservator there. And I'm going to just write down that that was a proper conservative, that he did a proper action. But let's talk about the actual conveyance. Let's talk about that 2017 codicil. It says that Sid prepared a codicil given, again, that word just sticks out, 1/2 of the interest in State X to Hank's best friend Bill. Again, the rule, which we're not going to discuss, but that house is in State X. It's probably not going to be quasi-community property. And I do want to emphasize on the facts here, given 1/2 of the interest in the State X to Hank's best friend. Now, again, you could have said, hey, look, maybe Bill is a bona fide purchaser for value. They're giving you those facts. Again, they want you to discuss those facts. The conclusion here is that Billy will probably get 1/2 of the house and hubby will get the other half. And of course, we have that will from 2008 from hubby that says it's going to go on to my wife. Disposition, wifey will get 1/2 and Billy boy gets the other half. Question 3. Will Hank's creditors be able to reach the assets in the trust? And what do we have here? We have a revocable trust. It's not a spendthrift trust. And that means that the creditors can probably go and reach into that trust, and the surviving spouse will probably be personally liable for that debt. Why? Because we're in a community property state. Now, the rule is that the creditors can reach to the extent of such personal liability that is limited to the value of the community property received. It means that Wendy cannot be responsible for more than the value of the property that is found within that trust. So I hope this video helped. I wish everyone all the best, and I hope you passed.